case involving post-employment restrictions between Estee Lauder versus former employee Sashi Batra.
My client hired Mr. Batra on January 5, 2004 as the Global General Brand Manager. Effective July 1, 2005, Mr. Batra also assumed the role of General Manager for Darfin North America. As a senior executive, some of Mr. Batra's duties included research and development, marketing and distribution, pricing, packaging, development, corporate finance, regulatory affairs, and public relations. With this promotion, Mr. Batra signed an employment agreement that included a confidentiality, a non-solicitation, and a non-competition clause. In March of 2006, Mr. Batra phoned Estee Lauder executives to inform them that he was resigning with the firm to work as worldwide general manager of Perricone, a direct competitor of Estee Lauder. At this time, Estee Lauder executives reminded Mr. Batra of his prior commitment with the company, and Mr. Batra acknowledged these obligations. Mr. Batra has trade secret acknowledgement that could potentially devastate Estee Lauder. He holds insider information about intricate parts of Estee Lauder Company, and the possible damages are irreparable if leaked into the hands of their competitors. With this, we ask you to impose a temporary restraining order on Mr. Batra from breaching the terms of his confidentiality, non-solicitation, and non-competition agreement with Estee Lauder, and from engaging in employment with Perricone.
My client, Sashi Batra, is asking the court to apply California law in this case. This would allow the non-compete agreement my client signed to be null and void. Also, my client is claiming he does not know any trade secrets or enough information to damage Estee Lauder. We feel Estee Lauder should prove irreparable injury from my client working from a competitor. Lastly, my client feels that he is entitled to 12 months compensation.
In response to the three requests made by the defendant, this court will impose New York state law because New York has a greater material interest. Estee Lauder's management and control are in New York, and New York law is more appropriate for companies and employees who possess trade secrets and confidential information. The plaintiff has effectively proven that Mr. Batra does have intimate knowledge of current and upcoming products, all of which proves his knowledge of trade secrets. Because Mr. Batra contains trade secrets and sought employment with a direct competitor of Estee Lauder, the plaintiff has shown that their interests will suffer irreparable injury due to Batra. Under the employment agreement signed by Batra with Estee Lauder, Mr. Batra is entitled to injunctive relief up to 12 months. But it is the ruling of this court that Mr. Batra receives only 5 months of regular salary compensation. During that 5 months, Mr. Batra is restricted from working for any direct competitors of Estee Lauder. This will adequately protect Estee Lauder's trade secrets on upcoming products and follow New York's policies on restrictive covenants.
As representative of Estee Lauder, how do you feel about the decision?
We believe the decision is fair, and we're just glad to have this trial over with.
Mr. Batra, how do you feel about the decision?
Oh, I was totally baffled. I thought they were going to use California law, but they went with the New York. And now I only get 5 months, and I can't even get a job doing that. Maybe I could go to a non-competitor, but that's about it.